Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about requests for counsel made by Indigenous persons. Cases that should have gone to the Supreme Court of Canada, but didn't. An individual was arrested in a very complex murder investigation with a lot of significant theories of the case that dealt with complicated legal issues. In the course of her being interrogated by police, after she had had contact with counsel and the opportunity to obtain legal advice, she repeatedly asked again to be put in touch with legal counsel. Unfortunately, the law in Canada is that unless there is a significant change in circumstances, a person is not really entitled to speak to a lawyer again once they've already implemented their legal obligations and obtained legal advice, unless, of course, the person is dissatisfied with the call. In the circumstances, though, this was an Indigenous accused who was at a significant power imbalance vis-a-vis the justice system as a whole, the multiple police officers who were involved in a lengthy interrogation about a complex area of law. And the question that the Supreme Court of Canada was asked to weigh in on was, does this framework, does this framing of the accused change in any way the analysis about whether or not somebody should be permitted another opportunity to consult with counsel? And from my perspective, this is a very important question. We know that statistically in Canada, Indigenous people are overrepresented as accused persons in the criminal justice system. Statistically, Indigenous people are less likely to be represented by a lawyer, and when they are represented by a lawyer, they are less likely to spend meaningful time with their lawyer in preparation for their case compared to non-Indigenous people entering the justice system. They're also overrepresented in incarceration, typically given higher sentences, and overrepresented as victims of crime, and overrepresented generally in violent crime. And so when you have this confluence of factors that creates a very significant systemic power imbalance, should a person's Indigenous heritage not be considered in how the police implement contact with counsel, especially because we know oftentimes for Indigenous people, contact with counsel is inadequate? This would be the perfect opportunity for the Supreme Court of Canada to engage in a discussion and a dialogue with practitioners on the ground, both police and defense counsel, about our obligations in the Truth and Reconciliation Commission report, and to implement those recommendations through changing jurisprudence to consider the specific circumstances that affect Indigenous people vis-a-vis the rest of the population. And unfortunately, they didn't really see the significance of this issue to a broader problem that we have when it comes to Indigenous overrepresentation in the justice system. Hopefully, the Supreme Court of Canada will have another opportunity to reconsider the issue of whether there should be different treatment for the right to counsel based on a person's level of power imbalance, but that's not coming anytime soon. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you for watching, and like, subscribe, and share with your friends.